Documents we saw you go to the Supreme Court with. Thank you very much, Jackson, for joining us here on a KTN News Desk. A number of people have only seen you on TV thanks to that particular petition. But really, who is Jackson Awele?
Well, Jackson Awele is an advocate of the High Court of Kenya. I was admitted to the bar in the year 2010. I studied at Moi University, Annex School of Law, and thereafter went on to undertake my pupillage with the law firm of Kaplan and Stratton. And about 3 years later, joined the firm that initially filed the 2013 petition, Oraro and Company Advocates. So it was after, again, a short stint at Oraro and Company Advocates, just about 3 years, that I ventured out to partner with my now partner, Medlin Murumba, to start Murumba and Awele Advocates.
So you've been finding yourself in the middle of presidential petitions?
Well, as fate would have it, yes. Since the promulgation of the new constitution, I have been, would it be right to say fortunate enough to participate in both presidential election petitions, and with it, you know, a lot of experiences to talk about going forward.
What role did Murumba and Awele play in this particular petition that was filed by the opposition seeking for the nullification of the elections?
We'd have to go back a little bit from the electioneering period. The official period, well, in Kenya, there never seems to be an official period for campaigns.
Yes.
But from early this year, we got very much involved in the petitions, the numerous petitions that the National Super Alliance filed in court, challenging various issues that, came up in the political sphere. And so there was the need for the capacity for all levels of lawyers to assist in the filing of these petitions. You will realize that most of them had to be filed within specific timeframes in order to achieve the objective that they sought, so to speak. So that is a period that I got involved. Of course, some of the lawyers that were actively involved in the political sphere of it all were also part of the team that worked with the 2013 elections.
Yes.
And so it is at that point that, we were, we got together as a team and agreed on how we were going to work essentially to assist the political agenda of the National Super Alliance go forward. So it is through the successive petitions that we filed before the presidential election petition that we now found ourselves in the middle of the presidential election petition.
This particular petition, we understand, was filed in a very short period of time. You had almost 48 hours to put together a watertight case, because initially NASA had said they will not be seeking the services of the court to address their grievances, but they made an about turn. How was that for you?
Yeah, that's the most interesting part, because having filed all these petitions just prior to the presidential election, we really did not expect as lawyers that when now we are faced with the greatest injustice of them all, that we would just be relegated to the back burner and told to sit there and
we are not seeking services of the courts.
So I have to say that as lawyers, we really never bought that narrative, because in the end, if the client decided to instruct us one day to the a deadline for the filing of presidential election petitions, then we were the ones who were going to find ourselves in problems. And so working with a very small team of lawyers initially, we agreed that we were going to document all the problems that we see with this election, and that we were going to start the drafting nonetheless. And so as all the political machinations went on behind the scenes and at Bomas and whatnot, the rest of us were busy burning the midnight oil, trying to come up with at least a framework petition that was then to be fleshed out to what it later on became. So when the client finally made the decision to instruct us, it came as a, as a good relief to us that we were actually going to continue with the work that we had started.
So you actually started drafting this even when the whole country knew NASA will not be seeking services of the court to address the issues they've been raising.
I have to admit so. Behind, of course, the knowledge of the client, because for us, this was also, for us, a conviction. It was, for us, something that we believed in. And so our beliefs did not have to depend on what the client felt. And we were happy in the end that our beliefs matched, because had it been that we did not receive the instructions to proceed and file suit, because we could not drag the name of the client to court to file suit, we had to get instructions, then I think it would have been a great disappointment for us, even as professionals, for the work that we know we have put in throughout this electioneering period. Only, then to put down or lay down our tools at the very time, at the time that we were most, perhaps, I think, needed by the public at large.
We have seen lawyers file petitions even without seeking to have a client to do so. They are grieved person themselves. In the event that Raila Odinga would have decided he does not want to file a petition, would you have filed it anyway?
Probably not, because as you know, the filing of a presidential election petition involves quite a bit of resources. You will need a client who is able to take care of all that. You'll need a client who has the goodwill of people across the divide, professionals from every, of every capacity, so to speak. I have to say that in the hours leading up to the filing of this presidential election petition, we got quite a bit of input and assistance from so many well-wishers and friends who ordinarily would not work without a deposit or fees. And so that speaks to the amount of goodwill that this particular client is probably the only one who could marshal to enable us do what we did, the so-called 25,000-page petition.
From the word go, did you believe that you had a watertight case even when you were starting all this drafting behind the back of your client?
Oh,
did you believe that you had a watertight case?
Oh, yes, certainly, certainly. I think we have always believed in the cases that we have filed throughout this electioneering period, and I think even previously. I think the only problem that we as Kenyans have always faced has always been the perception that the judiciary is also divided along political lines. And so even as you file a petition, much as the law may be on your side, on all fours, you always have to understand the philosophical and political leanings of the bench. And this is not something that is unique to the Kenyan situation. And so we very much believed in our case. We had some of the best legal minds, sitting together in a room and debating some of the issues that we were going to discuss. And we were confident that for any objective person sitting in at the Supreme Court, looking at whatever documents we have placed before them, the case that we presented to them was one that warranted the orders that we eventually got. And so as it turned out, this time around they believed in us, and we were persuasive enough to get the decision that we wanted. But as you can see, not everyone, agreed with us.
Yes, and looking at the dissenting views from the judges of the Supreme Court, Jackton Ojwang and Njoki Ndung'u, also seemed to poke holes in the manner in which the case was put up. What are your thoughts about the dissenting views that were given by the two?
Exactly. I mean, yeah, and as I said, not everyone believed in the merits of the case that we filed. I listened to the decisions of the Honorable Justice J.B. Ojwang and the Lady Justice Njoki Ndung'u. They are quite detailed decisions. But one thing that I have to say, of course, and probably I may not be objective in my interpretation of what they were saying, but I strongly disagree with the manner in which they interpreted the Constitution as a whole. I think their dissenting decisions had a number of contradictory positions within their own decisions, and also between even the dissenting decisions almost contradicted themselves in a number of legal and philosophical issues. And so we have raised a number of issues that, as a legal team, we shall also be raising with the public, just for, public awareness in the few weeks to come. But I have to say that from where I sit, having read the dissenting positions of the both justices, I really do not believe that they were speaking to the legal regime as provided for under this Constitution. And particularly considering some of the comparative legal regimes that they were using to justify the conclusions that they arrived at.
Finally, before I let you go, this particular petition has been historic, will go down history in this country for presidential election to be annulled. Where do you think this places us as a country?
Well, I think it basically speaks to yet another tenet of this Constitution that we have, Article 259 of the Constitution, that requires that in the interpretation of the Constitution, the judges should always strive to promote good governance, develop the law, and basically also promote the national values and principles upon which our republic is founded. I think for us, the judgment has set the ball rolling in terms of enjoying the fruits of the Constitution that we fought so hard to get. And I think from here we cannot go back. I think we have solidified our position as a democratic state, as a constitutional republic. And for me, as a lawyer, I think I can only rejoice in the fact that Kenyans have finally gotten what they for so long yearned for, and for anyone to take us back to where we came from, they would have to sort of pull off some magical moves in order to take us there. But for now, I think from the decision that we have, we are probably going to see a more circumspect IEBC going forward. We're going to see more respect for processes and institutions that have been established under our Constitution, and generally a more robust democratic state where we engage, freely despite our various political leanings from whichever part of the country.
All right, Jackson, thank you very much for coming here on KTN News Desk. Jackson Awele from the Murumba and Awele Advocates law firm that played a very critical role in that particular petition filed by Raila Odinga that nullified that particular election where IEBC chairperson Wafula Chebukati announced President Uhuru Kenyatta as a president. Quite a historic one there. And of course, always a pleasure once again. Thank you very much for joining us here on KTN News Desk. Now, in Uganda, the storm on the age limit debate has gone down, at least momentarily, as the Deputy Speaker of Parliament, Jacob Oluwanya, pushed the discussion to next week. Shock outbursts, singing and dancing was the order of the day when opposition members of the parliamentary ground activities at the chambers to a halt. Not even the intervention by the Prime Minister and leader of government business